LMS, I'd like to thank you for dedicating your time to join us today for an educational training session. This session covers important matters related to your service as an association board member. We anticipate the presentation will last approximately 30 minutes. Should you have questions during the presentation, please submit them through the question window on the right of your PC screen or by tapping the question icon on your tablet or smartphone. These questions will be addressed after the presentation as time allows. Attendees will be muted during the presentation. Joining us today is our featured presenter, Kerry Bartell. Kerry is a principal with the law firm of Kovitz, Shifrin, Nesbit. She specializes in common interest community association law. Kerry's expertise includes providing guidance on general matters relating to associations, as well as counseling the board of directors on corporate actions, contracts, and dispute resolution. Kerry conducts seminars and webinars for homeowners, property managers, and community associations. She's a frequent speaker at industry trade shows and has written numerous articles featured in publications such as the Chicago Tribune, Common Interest, and the Chicagoland Cooperator. Kerry is also actively involved with the Community Association Institute, CAI, where she served as Illinois chapter president. We're privileged to have Kerry present our 2017 LMS Board Member Boot Camp.
Hello, everybody, and welcome. I'm very excited to be presenting this today, and hopefully we can impart some knowledge about how and what to do now that you're on the board. We're going to talk about a number of different topics. There's actually quite a bit we could cover, so this is going to be somewhat surface, but hopefully we'll give you a good idea of where you need to head now that you're on the board. We're going to be talking about 4 different topics and why this is important. First, we need to know how to operate legally, we need to know how to operate efficiently, and we need to know how to operate without undue personal liability exposure, and that is mostly through delegation and the use of professionals. And finally, we want to try to involve the owners as much as possible. So let's just give a little bit of brief background. How do we establish the condominium? There are basically 3 sets of governing documents that are going to be specific to each association. Those are your declaration, your bylaws, and the articles of incorporation. Keep in mind the declaration is the document that includes all of the recorded covenants and deed restrictions for the property. The bylaws are then the operating procedures and requirements of the association as a corporation. And the articles of incorporation for condominium association actually are relatively brief, but it tells us who the board is and who your registered agent is going to be as well. We then also have to look at governing law. Obviously, for a condominium association, that's the Condominium Property Act. If you're not a condo, you may look at the Common Interest Community Act or the Section 18.5 of the Condo Act, which applies to master associations. And then we also have the General Not-for-Profit Corporation Act. We're going to be talking mostly in terms of condominium associations today, only because that's the majority of associations in Chicagoland. If you are a SECA association or a master association, much of this is going to apply anyway, but I encourage you to talk to your attorney to see if there's any nuances on the different topics we're going to discuss. So, association operations. First, the administration of the association and your board of directors. Obviously, board of directors are elected by the ownership pursuant to whatever the procedures and requirements are of your particular association. Qualifications for candidates of the board are actually quite simple. Under the Illinois Condominium Property Act, the only qualification for serving on your board is that you are on title or own a unit. I've had several associations that want to adopt what I call good standing rules, where you have to be current in your assessments or you can't have any violations. that is not enforceable. Those types of rules are not enforceable. So if you have those types of provisions, whether in your declaration or in your rules, it is my belief that those are unenforceable, and you can only look to whether or not the owner is on title or the candidate is on title. Your declaration is also going to give you the procedures for removal. Interestingly, the Condo Act does not have minimum requirements for removal, so it is solely based on your particular association's bylaws. Typically, I will say that it is somewhere between 2/3 and 75% of your ownership, so that's everybody in the association, in order to remove a board member. The idea is that it should be hard, and it can be quite a process. So if that's an issue for you, again, I would speak to your association's counsel to see what your particular provisions are. So what are the roles of board members? You actually have quite a wide breadth, and as a result, you have quite a lot of power. Obviously, it's management of the association, and that is both the corporate entity and management of the property. So you have to make sure that you're paying attention to both sides of that. Obviously, the financial obligations are managed and overseen by the board of directors. Property value. One of your objectives and one of your obligations is to ensure that you are maintaining the property value for the association as a whole and the individual unit. And fourth is safety. You need to make sure that your owners are safe and secure in the operation and use of their units. Okay, so now we're going to go into a little bit more detail. The role of board officers. So while the ownership elects the board members at large, in other words, you're just electing 3, 5, 7, however many your bylaws call for, you are electing the board members to the board generally. It is then the decision of the board members to determine who is going to serve as their officers. So the election of officers and subsequently the removal of officers is simply a board decision. That should occur, in my opinion, immediately following your annual election. Typically, officer positions roll over on an annual basis as you get new board members from your election. But again, you should look at your bylaws to determine how that is conducted. Most associations will have 4 officers, although some do not have a vice president. You must have a president, a secretary, and a treasurer. The president is essentially the CEO of the corporation. He or she will oversee the operations of the board and the association. Often the president is the one that will sign contracts or other legal documents binding the association. And there can be other roles that the president may or may not have. The secretary is the keeper of the minutes and the keeper of the records. Now, many associations these days have either a recording secretary or have somebody else actually take the minutes at your board meetings, but it is the secretary's job then to review them and make sure that they are accurate. The treasurer obviously is the person who oversees the finances. Make sure that the financial records are accurate, manages the accounts, and conducts whatever other financial business that the board may authorize that person to do. Now, the treasurer, unless the rest of the board has made a motion to vote to give the treasurer power, the treasurer cannot act on its own. The treasurer does not get to approve expenditures, does not get to change funds from account to account without the otherwise express authority of the board. So make sure that if that's what you're doing and that's how you conduct business, or your treasurer has those powers, that there's a board motion in the minutes that reflects that you've transferred that power to the treasurer. Finally is the vice president. Again, many associations may or may not have a vice president. The vice president really is just supposed to step into the role of the president if the president is unable to serve. Now, I will say, and I may mention this later on as well, in fact, I think I do, simply because you're a board officer does not mean that you get quote-unquote extra power or get an extra vote. These are just actually additional duties that the officers have to take on. Their power or their voting power within the board is the same as anybody else. Okay, meetings, the fun part. Meetings used to be very simple and easy, and we all kind of, went about our business until the four-letter word entered our lives, Mr. Palm. So with the Palm case, meetings have now become much more structured, and there are a lot more restrictions and obligations with respect to how you hold, how you call, and how you conduct meetings. So let's start with unit owner meetings. I think we skipped a slide. Did we skip a slide, or did we? Okay, let's start with unit owner meetings, and then I'll go back to board meetings. So the unit owner meetings are actually pretty minimal. There's only a couple. So the first one and the most obvious is the annual meeting. The annual meeting must occur every year, and it is the meeting where you elect your board members. Typically, the only thing on the agenda at your annual meeting should be the election. Some associations do the IRS resolution every year, or there might be updates or president's report or information given at those meetings. But the only purpose and the only thing on the agenda at your annual meeting should be the election itself. Other owner meetings are any meetings that address adoption or adoption of the budget or regular assessment, or special assessments. Under the Act, the association has to give notice of any meeting where you plan to vote on the adoption of the budget or a special assessment or a budget increase, and that is technically an owner's meeting, the discussion is. And then finally, amendments to the declaration. If you are proposing an amendment to your declaration, leasing restriction, pet restriction, anything like that, you need to call an owner's meeting in order to conduct a formal vote on that amendment. So notice for owners' meetings. Most association declarations, again, this is something that Palm brought up, you need to check your declaration to make sure what your notice procedures are. Some associations are a little bit different, but the majority of them say that you have to mail or deliver notices of meetings to all owners and post the notice if you have a common entranceway or mailroom where more than 7 units come and go. So it is posting and then also mail or delivery. You also now have the ability under the statutes, this was a change within the last couple of years, that allows an association to adopt rules that would provide for notice by electronic delivery. This is email. However, if you're going to use electronic notice, a couple things to keep in mind. One, you have to adopt rules and regulations providing for that system. Two, owners have to affirmatively opt in to the use of emails. Even if an owner has given you their email address or you for some reason have it on your system already, you need that opt-in form from the owner saying, yes, I agree to accept notice and other association documents, i.e. the budget, through this email account. And they have to sign that. You need to keep that on file. So make sure, again, that you talk to the association's counsel to make sure that you have the right forms and everything in place and the rules in place. The final note on unit owner meetings. Under the Condo Act, notice of owners' meetings must be mailed or delivered and posted no less than 10 days nor more than 30 days prior to the date of that meeting. The notice must also obviously state the place, the date, the time, and the purpose of the meeting. You need to be careful and clear as to the purpose. The judges recently, we've had a couple cases where they're really starting to look at whether or not the purpose of the meeting was clearly stated on the notice. Okay, so union owner meetings continue. So unit owner meetings are chaired by the president, always. So even if you have a unit owner meeting that is the result of a petition from your homeowners, so you get a petition signed by the owners, and it says, we want you to hold a meeting on such and such a topic. Even though the owners called it, the board president is still the chair of that meeting and runs it. So, make sure that at least the president is at that meeting. Quorum, under the Illinois Condominium Property Act, quorum is 20% of your membership if you have 20 or more units. If you have less than 20 units, then it is governed by whatever your declaration or bylaws provides. For non-condo associations, and if you're under SECA, you are 20% as well, unless your declaration or bylaws provide for a lesser amount. So for SECA, you cannot be more than 20%. Last note is that proxies are permitted in unit owner meetings. Proxies must be signed, dated, and include a time limit. If the proxy is silent, then the longest that a proxy can last is 11 months. So make sure, again, if you want to have your attorney review your proxies and make sure they're valid, that's probably a good idea. Note that for elections, and we'll talk, I don't know if we go into elections because I think that's a whole nother seminar, but you can eliminate proxies with the adoption of absentee ballot rules. But again, that's sort of another topic for another day. I'm sure there'll be seminars on elections and meetings as well. What is the role of the owners at your owner meetings and board meetings, quite frankly? You do have an open meeting requirement, but that only means that owners have a right to attend and listen at the meeting. They do not have a right to participate. I know a lot of associations sort of like the free flow of information. The concern with that is that your board meetings, one, can be 5 hours long. Two, the board really needs to stick to its agenda. That is your business meeting for the corporation. They have a right to participate, and that's all. Information is key. So my recommendation and what I've seen be most successful for my associations is particularly that when there's a hot topic for the association, provide information. Have your experts there if that's what you need, if it's a big project or what have you. Have your attorney there if there's a contentious issue. But the more information you can provide, the better. Okay. I'm going to go, let's go back because I think we're missing one of the slides. Yeah. So one of the slides was missing. I apologize, but this is kind of important. So board meetings, which is really where the majority of the Palm case kind of came into effect, and now subsequent legislative changes that have occurred in the last 2 years. So for board meetings, notice is 48 hours, and it's not 10 to 30 days. I get that confusion. So unit owner meetings, 10 to 30 days. Board meetings are going to be 48 hours. For 99% of the associations, your quorum for a board meeting is a majority of the board members must be present in order to have and conduct that board meeting. When you are at the meeting, any decisions can be made by the approval of a majority of the quorum. So let me say that again. If you have a quorum of, if you have a board member of 5 people, your quorum is 3. If at that meeting you only have 3 present, in order to pass something, you only need 2 of those 3. So sometimes you can get things done a little bit easier. Again, as I said earlier, it is 1 vote per board member regardless of officer designations. Board members cannot vote by proxy. There's no mechanism in any of the statutes, quite frankly, that allows a board member to vote by proxy. However, board members can be present via conference call or via Skype or FaceTime. There's a number of different ways to do that as well. So if you have board members that can't be there, they can call in or they can Skype in and participate that way. Special meetings of the board are called by the president or 1/3 of the board. Finally, you have to have a minimum of 4 board meetings per year. That is required, again, by all of the statutes. So you need to have at least 4. A lot of associations take care of one of those by calling a board meeting to immediately follow the annual meeting, and that board meeting is where you're going to elect your officers. So make sure that you're conducting enough board meetings. finally, and this is one of the statutory changes that came in on January 1 of this year. So as we alluded to earlier, all board meetings must be open to the owners in order for them to listen. However, there is an exception under these statutes which allows the board to go into a closed session. Some people call it executive session, and that is to discuss certain issues that might come before the board. Two changes that happened in the statute this year. One, you can have an executive session or a closed session of a meeting without having to call a formal board meeting. In other words, you don't have to send out notice 48 hours ahead of time if all you have on your agenda are executive session matters. The items that can be discussed in closed session, and this was expanded January 1, is litigation, violations, assessment collection matters, and then here are the two new ones that were either expanded or added. Employment or dismissal of employees, independent contractors, agents, or any provider of goods and services to the association. This is much broader. It used to just say employees. So what this allows the board to do, I'll give you an example. What this allows the board to do now is, let's say you want to have a new landscaper service the property, and you want to interview 3 different companies who may or may not be hired by the association to do that service. You can now have those interview sessions with the entire board there and not have to, 1, open it up to your owners, or 2, send notice to all of your board or all of your ownership. The other thing that you can do now too is you can do a landscape walk, or an sort of, do a review of your property with a majority of the board there without having to call a meeting and then go into executive session, because you are making sure there's no violations. So it's under that umbrella. So this gives the board a little bit more leeway in conducting business. You also now can meet with your attorney without having to do it at a meeting or in front of the ownership. This was not, remarkably, was not an exception to the open meeting rule. So now you can meet your attorney. Although I've been asked now several times, well, can we just keep you on speakerphone at our meeting so then we don't have to notice it and we can do it in executive session? Don't use and abuse, but it is there now. The final change that was made was that it used to just say discussion of these matters. Now it is discussion or to consider any information related to these matters. So it's a little bit broader. Final warning about closed sessions, and then we can move on. The closed session, executive session, is to be used for discussion purposes only. If you need to vote on anything that occurs in that closed session, that has to be done then later in an open meeting. So make sure your votes are later on. Okay, moving on. Fiduciary duty, the scary words. So where does it come from? It is explicitly stated in the Condominium Property Act that board members are fiduciaries for the association. There's also countless cases that discuss the fact that board members do have a fiduciary duty. What does that mean? It means you have a duty of care. You need to reasonably investigate problems or issues, violations that are reported, all those fun things that come up to the board. And then you have to give a reasonable response based upon appropriate deliberation. Your answer can be, we're not going to do anything, but it has to be after a discussion about that. Third, use of and assemble a team of professional advisors and delegating. This is where you're going to use your property manager, your attorney, your accountant, your banker, insurance agent or broker, engineer and architects, and always require proof of insurance as well. That's what your experts are there for, and quite frankly, which came out of the Palm case as well. If the association board relied on a professional in making a decision, even if that decision was ultimately wrong or misguided, the board has a defense for a breach of fiduciary duty claim if they have in writing from an expert or one of their advisors that they could proceed in that manner. So it is a defense, an absolute defense, quite frankly, of a breach of fiduciary duty claim. So get those opinions in writing. Duty of care, again, every decision that you make is going to be in terms of what is the expenditure, what is the liability risk, And the courts and the law recognize that you have to balance those two things. Again, you are looking at the total picture, and you need to look at the practical impact of any decision that you made, and that is okay. Duty of loyalty. This is where some board members sometimes have a hard time. Interest of the association is paramount. That means it always wins. You have to look at the good of the whole, not your individual interests. The association's interests will trump individual preferences. It will also trump preferences of any particular group or faction within your association. Conflicts of interest. You can't have them. So, make sure that there's no conflicts of interest, either monetary or otherwise. Interestingly, the statutes require disclosure of a conflict of interest. So if a board member has a company and the board decides to hire that company, the only requirement is disclosure. You're not prevented from entering into that contract. And then that board member shouldn't vote and have objective fairness. I'm trying to go quickly because we're running short on time. See, I could talk for hours. Okay. Review of board decisions. Illinois has adopted the business judgment rule, and that means, quite frankly, there will be no judicial second guessing of decisions, even if things don't work out as hoped. They focus on the process, not the result. Again, a standard of reasonableness. Make sure that there's a robust discussion if necessary. And the board generally has broad discretion, even with money. I put a note to myself on this. When you're doing budgets, or make sure that you have to send out notice of the meeting to adopt the budget along with a copy of the proposed budget. The statute was recently changed for condos to reduce that notice period with the copy of the budget from 30 days to 25 days, so that's good. Purchase or sale of property, appointments of vacant positions, and expenditure limitations. These are all going to be governed within your declaration and bylaws. I listed them here because each association is a little bit different. So if you're thinking of doing any of these things, consult your attorney to make sure that you're following the procedures required for your association. Do you see all the shameless plugs for attorneys? Yeah. Okay. Anyway, it's always good. So channels of communication and chain of command. Use of your property manager. Make sure that you are clear with your property manager and frankly, any other experts or advisors that you may have as to who is your designated contact with that outside professional. One of the worst things I know as an attorney that happens to me, and I'm sure it happens to managers as well and other experts, is getting the same question from 5 different board members that's slightly different, so then I don't know really what the question is. So set up those channels of communication and the chain of command with regard to communication. Same with owners. Make sure that even if you disagree or you have board members that disagree, the communications to the owners is coming from one person, and it is a unified front. Confusion is your worst enemy as a board. Okay, financial assets. We touched on a lot of this previously. Make sure that you establish an accurate budget, assessment, special assessment if you need one. They all require notice to members. However, they are only adopted by the board. There may be owner petition rights, but again, that's something you should work through with your attorney. And also, this is where your property manager and even your accountant on some level can really help you make sure that you have an accurate budget and accurate special assessments should you need one. Collection of assessments. You cannot forbear, you cannot forgive the payment of assessments for any owner. Remedies, late charges, you can assess late charges. They have to be reasonable. Some association declarations also provide for interest, although the interest ends up being like $3 a month. It's not particularly effective. Legal action. You do have the right to get a personal judgment against the owner as well as a victim from their unit, which is very, very powerful with regard to collection. Make sure that you have a policy in place for unpaid assessments and your collections. That is something that your attorney can also review. Reserves, you have to have them. Make sure that you have reserves. Make sure that they're reasonable. They do not need to break your bank or make your assessments unattainable for your owners. However, there's a balance there. A reserve study is a great tool to figure out where your reserves should be. Proper approval of expenditures. Approve all of your expenditures at a meeting. That it requires a vote of your board members. You can have budgeted expenditures, then you give your authorization to either your manager or a particular board member to approve those budgeted expenditures, but you need those resolutions in place in order to have that automatic process. Again, that's a POM issue. Owner approval required. Some associations do have expenditure approval requirements that only will apply to additions, alterations, or improvements of the of the common areas. They cannot be applied to regular maintenance, repair, or replacement of the existing common elements. Good example, you have a lobby, you have a cement floor, the board wants to put in a marble floor, and you have a expenditure limitation which requires owner approval. That improvement would be subject to owner approval if it's in your declaration. If you're just replacing it with a new floor, same material, then it's a board decision no matter the cost. Periodic audit, I generally recommend that you have an audit or a financial review done at least every couple of years just to make sure that the board is, all the finances are clear. Okay, a couple more things and then we'll be done. Protection of association property, remember we mentioned this at the beginning. Make sure that you're adequately maintaining, repairing, and replacing the existing property. This includes reserve or useful life study can help you do that, a set maintenance schedule, both short-term and long-term, inspections, limited common elements are reviewed, and also look at funding alternatives. This can be loans, this can be special assessments. There's a number of different ways to do it. Contract procedures. You need to make sure that you have specifications for the work and then bid it out. You do approve contracts at a meeting and then make sure if it's a large project that you have supervision. On the contracts, again, shameless plug for attorneys number 85. I cannot stress this enough. Make sure that your attorney is approving your contracts. 95% of the contracts that I see are horrible for associations. There are no protections for you should something go wrong. And we can very easily prepare a rider that will protect the association in the event something does go wrong. So make sure that your attorneys are approving and reviewing those contracts. Okay, almost there, almost there. Rules and regulations, we'll go through this. Again, this could be another 2-hour seminar. The board adopts rules and regulations, period. They cannot be inconsistent or supersede the declaration and bylaws. There's new case law that specifically states that. You need to have enforcement procedures in place, and that includes fines, other penalties. But if you're going to assess a fine, you have to give the owner notice and the opportunity for a hearing before those fines are placed on that owner's account. So that's another restatement. We just talked about that. Litigation is generally going to involve collection of assessments, obviously is the most common. We can also get injunctions if an owner is violating your rules and they won't stop doing it. We can file an injunction action, and the owner will be responsible for your attorney's fees as well, and that's under the statute. Damages, obviously, if they're involved, we would add that as well. So I know I just ran through the last couple of slides, but I hope I gave you a good general overview of sort of the different aspects that the board needs to be aware of. Obviously, any of these topics could be a webinar on their own, but this is hopefully a good overview.
So at this point, we'll be addressing a few of the questions that came in from our attendees right now. This is Brian Butler. I'm also a Regional Director with Lieberman Management Services. And we'll just go through as many as we have in the time allotted. So one of the questions that came in from one of our attendees related to the use of email by boards for topics that could be discussed in closed session. What are the limits of email as a best practice, and where should boards really be meeting in person to discuss these issues?
So emails are kind of a dangerous sword. Generally speaking, board members should stay away from discussing anything on email, and that came out of the POM decision. These recent changes in the statute, which occurred January 1, which allowed board members to meet in executive session without calling a meeting, seems to open a door for email discussion in an executive session for only those specific exceptions that we talked about, the 5 exceptions. I will say, though, I don't know how courts will determine that. It's just too new with the statute. We haven't seen anything come down. I would caution you that don't rely on email. I think that it is a dangerous habit to get into, and certainly if it's something that you are not sure if it should be in executive session or over email, err on the side of doing it in an open meeting. Your general procedure, your fallback procedure should always be discuss it in a meeting and vote in a meeting. You're not going to get in trouble that way.
One conception that is also out there is that if the decision is somehow unanimous, if there's written consent provided by all of the board members, that they can make a decision outside of a board meeting. Is that in fact true?
That comes from the Not-for-Profit Corporation Act. However, the Illinois Condominium Property Act, in that instance, I believe trumps the not-for-profit. Even with unanimous approval over email, there should be absolutely no voting over email. Even with the executive session matters, that is for discussion only. You have to vote in an open meeting. It has to be reflected in the minutes.
One last question on email. It's obviously a popular topic for today. But if the board does use email, should they use the reply to all function, or should they direct all correspondence to a specific board member or other designated representative like the president or the property manager?
Okay, so this is a good question. After the Palm decision, and before this recent change in the statute in Palm, that was my sort of rally cry. Get rid of that reply to all button, because the minute you reply to all, it is a quote-unquote discussion where you have a quorum of the board meeting over email to discuss board matters, and that's a violation of Palm. You need to send notice ahead of time. That is still true. That has not changed. That was not changed by the statute. So do not use reply to all. If the property manager or the president needs to sort of send out information or give the board information in preparation for a meeting, that is fine. And certainly if one board member has a question for the president or the manager, that can be a one-off conversation. But that reply all button is evil. Take it off your email. Don't use it. Pretend it doesn't exist.
Thank you. We have one question in regards to board members that would be attending by telephone conference or FaceTime or Skype. If this possibility or this technological system is in place to allow for someone to attend remotely, is the board under any obligation to provide that mechanism to owners to attend the meeting remotely?
These are such good questions. So no, you're not. So again, board members do not have to provide that mechanism for owners. The ability to participate via conference call or Skype or FaceTime is because the board members have to be present in person, so to speak, for board meetings. They can't vote by proxy. You have to have a location of where your board meeting is, even if I've had some associations that have had board meetings via conference call. They do not have, none of the board members are physically in the location. However, there needs to be a physical location for the owners to come and listen if that's what they want to do. Sometimes that can be, at a management office. All the managers just cringed. But it can be at the management office. It can be wherever that is. But you do not need to allow that technology to your ownership.
For those owners that may not be able to attend meetings, it has become easier to be able to record those either by video or audio. What is the board's obligation to record meetings, if any, and their obligation to make those recordings available to owners? And also, if owners want to record a meeting, what is their obligation in terms of making that happen?
So I was going to mix those two questions anyway. See, we think alike. So under the Condo Act, and I think SECA as well, if an owner requests the right to record either by video or just audio, The open portion of the board meeting, they have a right to do so under the statute. The board cannot say no. However, the board can adopt rules governing how those recordings are conducted. Some associations say, you know, the video camera can't block the view for anybody. The board has a right to request that an announcement is made that it's being recorded, sort of all of those protections. The board does not, however, independently have the obligation to record either video or audio, record the meetings on their own, and certainly you don't have the obligation to make those recordings available to anyone. The board is obligated to provide minutes to unit owners once they're approved, and that is the way that owners can see what's going on in the meeting. It is not through these recordings. The other thing too, and this is just a caution while I'm thinking about it, is that if an owner or the board is recording the meeting, make sure that that recording does not start until the meeting starts, and that as soon as the meeting is adjourned and or you go into a closed session, that that person is specifically asked to turn it off. We've had a couple of lawsuits where the recording kept going and people were chatting after the meeting and board members said things and it got caught on that recording, and I'm now facing that in court. So make sure that you're aware of it and that you make sure it's on and off at the appropriate time.
We have a question about sharing information with other associations. So Chicago is a city of neighborhoods, and are there any limits to the extent that associations can share information or questions with other associations in the neighborhood? There are oftentimes numerous similar buildings that may be facing similar issues, and it's always better to work together. So what limits should be in place for the board in terms of information they disclose?
So this is where attorney-client privilege comes into play and confidentiality. Much like with your ownership, I mean, you're going to sort of have the same rules as it applies to other owners. Anything that's confidential or any opinions from your counsel, any sort of litigation strategy, if there's a litigation issue, those cannot be provided because you will break the confidentiality or the attorney-client privilege that you may have. Beyond that, I think generally it's okay to share other information with other associations in order to gather you know, some more perspective on whatever issue that you're facing. Make sure that you stick to the facts. Make sure that you're not giving out individual owner information or, again, any attorney-client privilege information. Also, you cannot share contractor proposals. Proposals or bids from contractors are protected by the Condo Act, frankly, and also by the contractor's privacy. So make sure that you're aware of that. If you are concerned about providing information, certainly you can always run it by your attorney to see whether or not it should be distributed. And again, it's sort of that gut check. If you think that it might be an issue, check or don't provide it. You know, people usually have a pretty good idea what's confidential and what's not.
Thank you, Kerry. Just much of your advice today has been geared towards condominium associations, but we have a number of building co-ops that are also in attendance. So is there any specific advice that you would have regarding those co-ops in terms of the procedures that you've outlined for condominiums that may be slightly different for their specific circumstances?
Okay, thank you. So co-ops are their own little animal, and they are not governed by the Condo Act, SECA, or any of those. They are typically governed by the Business Corporations Act, which is different than the Not-for-Profit Corporation Act. The majority of what co-ops do is going to be governed by their bylaws and their shareholders agreement. So it is going to be specific for co-ops. I will say, though, for probably about 80% of what we talked about today, there is no guidance for co-ops or co-op boards as far as how you're supposed to operate. The Business Corporations Act is meant to apply to every corporation, whether, you know, co-ops are just a very small piece of that. My recommendation to co-ops typically is, one, have your attorney review it. If the bylaws or the shareholders agreement is not specific on a particular issue, I actually do recommend that the co-op follow the guidance from the Condo Act or what condos do. And the reason for that is because if it is ever contested and we're in court, a judge is going to have the same law that I have available, and they're going to say, well, there's really nothing for co-ops. What the heck am I going to do? Well, condos are the most similar to co-ops, although completely different structures, but they're the most similar to condos, and a judge is going to use that condo law as a guiding principle in making a decision on whether a co-op board acted reasonably and with fiduciary duty in mind. So, you know, I think a lot of this is still going to apply even if it doesn't specifically apply to co-ops.
So we have a few questions coming in regard to housekeeping matters. So routine practices by a board, including board meeting minutes. Are there suggestions that you have in terms of what should be included and not included in board meeting minutes, including maybe those residents who may be in attendance or questions that come up during an open forum? How do you see the meeting minutes working in terms of a business record for the association?
Well, Brian, you said it. They are the business record of the association, and that's how they need to be viewed. It is not a newsletter, and it is not a you know, forum to list everybody's complaints and concerns. They are the business records of the association, period. The only things that need to go in the minutes are when it was called, who attended from the board, or if it's an owner meeting, the quorum of owners that are present, and then the motions and decisions that were made at that meeting. Anything beyond that is technically not required to be in the minutes. They should really be about 1 page, maybe 2 pages. But with regard to homeowner forum, which Brian specifically brought up, there should absolutely never, ever, ever be minutes from homeowners forum. This has come back to bite a couple of our associations in the past, and the reason is, you know, an owner kind of makes an offhand comment in the homeowner forum, it ends up in the minutes, and let's say they say, well, I think that maybe I'm having a problem with my window. It gets written into the minutes, and then 6 months later, that owner has a window leak. Well, now we're in court, and the owner's attorney points to those minutes from 6 months prior and says, board, you were negligent. You knew about it back here, and you did nothing about it. So they can be a little bit dangerous, number one. Number two, it's just really not proper. You know, certainly if the manager or the secretary even wants to keep notes on the owner forum as sort of a means of follow-up or action items, that's fine, but they should not be in the formal minutes.
Thank you. Another routine matter that comes up quite frequently is the 22.1 disclosure, which is obviously something that every association should have and update regularly. What is your recommendation in terms of best practice about how often that should be updated in terms of the monthly board meeting?
So the 22.1 disclosure, it's called 22.1 because it's section 22.1 of the Condo Act. And that is the provision that says that a buyer has a right to request from the seller, which AKA means the association, certain disclosures or statements from the board prior to the sale. And that includes pending litigation. It includes any anticipated capital expenditures. It includes insurance information, all of that stuff. So the 22.1, I think at a minimum needs to be updated on an annual basis just to make sure that everything is still accurate. But if you have litigation or you have projects that are pending, that 22.1 should absolutely be amended as soon as you are made aware of a potential issue. And the reason for that is because the buyer has a right to rely on that document. And if the information is wrong, then we have some real liability. So if things are going on, either, again, large projects, if you have a lawsuit pending, certainly, or you think a lawsuit may happen, make sure that 22.1 is updated. And that is something that your manager and your attorney can help you with to make sure that everything is stated as you need. The 22.1 with regard to litigation disclosure, that paragraph really should be prepared by your attorney because you don't want to give too much or make too many promises. So make sure that your attorney is drafting that for you.
Thank you, Brian. This concludes the question and answer portion of the presentation. Again, we'd like to thank you for your participation in today's webinar. We'd also like to thank Kerry Bartell of Kovitz, Shifrin, Nesbit for this valuable information. As a reminder, the presentation will soon be posted to our website at liebermanmanagement.com. If you have further questions regarding governance or other association matters, please contact your Lieberman Management Services Regional Director or your association counsel. Thank you again for your partnership and your service to your association.